Welcome back. The Apex Court will tomorrow hear arguments in a landmark case on the definition of consent in sexual offences laws, including rape. The case stems from a challenge brought by a rape survivor, supported by the Embrace Project and the Centre for Applied Legal Studies, which has joined as an intervening party. They argue that the current legal definition of consent makes it harder for survivors to access justice, as it allows perpetrators to rely on mistaken belief as a defence. Let's unpack the story with Sibongile Ndashe. She's at the Initiative for Strategic Litigation, the Africa Executive Director. Sibongile, it's great to talk to you, and what an incredibly important story this is in a country with the levels of gender-based violence that we face.
It is an important case for different reasons, I think, from what you have stated. There is a contestation as to whether this defense actually does exist, in law. Quite a number of things have happened since the High Court gave its decision. In fact, some of those things happened before the High Court decision was rendered, but it was not brought to the attention of the court, or the court did not consider it in its decision. The Supreme Court of Appeal has rendered a decision on a similar point of law. And it basically says that there is no such defense, because what needs to happen is that the court has to take the totality of the facts into account. So there is a case that is mentioned in this case as one of the facts. So there's a case of the survivor in this case, and also there's another case, the State versus Togo case. So the State versus Togo case was before the appeal court when the High Court heard the Embrace Project case. So what is important is that the Constitutional Court case now has to look at this case now with the understanding that the Supreme Court of Appeal says this defense that has been found to be unconstitutional by the High Court, or this reading of the Sexual Offences Act, that the Supreme Court of Appeal says, actually, what we are dealing with here is a problem of misapplication of the law, but the problem is not necessarily the law itself. What makes this case on Thursday much different from the case that was heard in Pretoria is the entrant of an amicus curiae in the form of the Women's Legal Centre. The Women's Legal Centre was not a party in the High Court, but they had supported the National Prosecution Authority at the Supreme Court of Appeal. So for them, when they came in late into the High Court case, they were saying, we thought this issue actually has been resolved. So that's what makes this case important, because I do not know that in the history of the Constitutional Court, we have had 3 organizations that say they represent women's rights interest, and all 3 of them are not in agreement with each other on what needs to be done.
I can see you going through the different steps in your mind, because it's obviously not as simple as the Constitutional Court will hear arguments tomorrow on this case. As you say, a number of things have happened in the interim as well. Would it be fair to say that there is this distinction between what consent means and that this is really at the heart of this case, Sibongile? The fact that in the Sexual Offences Act, someone charged with rape can avoid conviction if they can show that they believed the complainant reasonably had consented to sex. So that's on the one hand. So if the Constitutional Court agrees with the High Court, it will mean a person accused of a sexual offence must actually prove that they had taken reasonable steps to ascertain that consent had been provided. So there's a hairline sort of distinction to be made now, because then the onus is on the accused versus the onus being on the potential victim.
No. The second part is the temporary relief that has been given by the court in the High Court to say that this is what needs to happen. And the Women's Legal Center actually raises challenges with these steps because the reasonable steps to ascertain that there is concern. And in their case, they are arguing that this can actually make the situation harder for rape survivors. So that's not necessarily kind of the argument, but it's the remedy that the High Court has presented. On the first point, the importance of the Supreme Court of Appeal decision is that it is saying this defense is not a defense in the way that it has been held to be a defense in the High Court. So if someone reasonably believed, because that's what the conversation has been about here, the public narrative, that if a perpetrator says, I reasonably believe that there was consent, then he can be let go. The Supreme Court of Appeal says, sorry, that's not what the Sexual Offences Act says. The Sexual Offences actually says the court must have regard to the totality of the evidence. So this distinction between objective and subjective, which is the foundation of this case, has now been kind of blown apart by the Supreme Court of Appeal. So now, if the Court of Appeal is saying, actually, it's the courts that failed to convict in the State versus Amos, in the State versus Togo. In fact, the Supreme Court of Appeal went ahead in the Togo case and reinstated the conviction and said there was no reason for the High Court, not to convict the person because this defense was wrongly applied. So here, the issue that we are now looking at, which is different, is whether this consent defense actually exists, at all. So the problem is the problem with the legislation, the Sexual Offences Act, or the problem is with the courts that are misapplying the sexual offences legislation.
Yeah, so as you say, the SCA is saying it's a case of the misapplication of the law. So what will happen in the Apex Court tomorrow then? Or what are we asking the Apex Court to do?
The Constitutional Court was asked the main question to confirm the order of constitutional invalidity that was made by the High Court in Pretoria. What is interesting and quite strange about this case is that the SCA decision was made at least 5 months before the High Court decision was made. So it's quite interesting that this, even though they use the facts of the Togo case in the decision as part of the argument of why this legal provision is wrong, they don't then look at whether it has been overturned or what actually happened to that case. So right now, it's basically restarting the conversation. So it's important to note that the Department of Justice and Constitutional Development has decided that it's going to be bound by the decision of this case, so it's no longer opposing. And that's interesting because the Women's Legal Center is going to court to say, we were not going to come into this fight, but we are coming now and basically doing the work that we think the Department of Justice and Constitutional Development should be doing by defending, the legislation. So this is an important conversation, more than just what's happening in court tomorrow. It's about the kind of cases that are going to the Constitutional Court and what we are asking the Constitutional Court, to do, in these kind of cases. For many people, this is an important case because we know that we are dealing with a scourge of gender-based violence and femicide. And we know that we are dealing with an issue of access to justice. So when you look at the history of this case, although there is a survivor, the survivor's rights are not what's up for determination before this case. So nothing is going to happen to someone who went through a very gruesome kind of attack because she is here in the public interest, to say that this law was actually applied to me. But the Supreme Court of Appeals is telling us that it was not because of the law. It was because the magistrate who decided your case used gender stereotype, rape myths, and all of that, and misapplied the law. And so it's not the law that you should actually be after. When talking about gender-based violence and femicide, part of the 30-year, kind of looking back 30 years of the Constitutional Court has been, what has the jurisprudence of the Constitutional Court done to actually help to deal with gender-based violence and femicide? And so one of the questions that we're asking ourselves is, how does this case actually contribute, to that? So if we are dealing with a problem of misapplication of the law, as the Supreme Court of Appeal says, then how are we engaging judicial bias, and the issue of race, means, and gender stereotype that rob a lot of victims of justice, of rape or sexual offenses broadly, justice. And I do think that that is the importance, of this case, because we keep on doing different things, So now it's the legislatures versus the court, who is failing women. So basically, for me, that's how I would term what is going to happen at the Constitutional Court. But whether the impact of this case is really going to help solve some of the problems that we have, there is no evidence of that, because this issue kind of came to public imagination after the Togo, rape case. Normally, when we do law reform, whether we are going to parliament or we are challenging constitutional provisions, you'll find that there are studies, that actually confirm the existence of the problem. And this case is not a case that sort of started like that. Yes, there is a survivor. Yes, there is Embrace Project. And here's the Center for Applied Legal Studies. But in terms of documenting this challenge, that there are normally people who are let go because of this defense, that's not something that has actually been studied. So there is a question as to whether this is one of the key problems that we should be kind of responding to. Of course, if the law is a problem, then the law can be changed. But where does this actually take us, when dealing with violence against women? Because most of these cases are determined at the regional court, and those case decisions are rarely published. So there is something that happened about this case, the Togo case, that it kind of caught the public attention. It was a high court decision, and an acting judge, who's a very well-known advocate, was presiding, and that was the thing that actually caught the public imagination. But where we need to go back to is whether these kind of legal issues are the legal issues that are actually moving, the needle. So part of it is that we do interventions that are evidence-based or that are actually responding to the real challenges. We do know that we have got very low kind of reporting. We know that prosecution is also very low. Although the conviction is high, because prosecutors take cases that they think they are going to win. One of the questions in the Togo case was whether, what surprised kind of most of us who followed these developments was with the facts of that case that there was a bold and brave prosecutor that actually said, I'm going to take a case of intimate partner violence, to court, because this actually really happened. The courts understand stranger danger, when someone has been attacked by someone that they do not know. So here the issue of consent doesn't really sort of come up. But, so this issue the issue of consent does not actually arise, in that question. But consent in itself, it's a big issue, in criminal cases, in sexual offense cases. And I think this is what the Center for Applied Legal Studies is trying to bring into this case. And for them, they are coming to court to actually appeal a decision, because the High Court said, not here, not in this case, and made a decision about separation of powers, that what the Center for Applied Legal Studies is asking for is basically something that should be asked for from Parliament, not from the court. Because what they were saying is that even if the High Court decision were to be upheld, it still will not solve the problem that we have when it comes to consent in rape cases. So they don't want consent to be part of the definition of rape. The Women's Legal Center also does not agree with this. So that's what makes this case important, in that there are three different positions held by organizations that work on women's rights. The Women's Legal Center was not there in the beginning, but the Women's Legal Center, just like the Center for Applied Legal Studies, have got a very long history of engaging the Constitutional Court on violence against women. And so I think the court will be interested in what the Women's Legal Center will have to say, even if they joined in quite late, as a friend of the court.
Sibongile, we're running out of time, but I just need to get one question in with you. If we talk about bias on the part of, because you say most of these cases are decided in regional courts, gender bias, etc., in the way these cases are decided, the courts and magistrates is where the problem lies in part. How do we even begin to address that?
One of the things that used to happen was this training, which was called social context, training, and we did see at that time, like law, race, and gender, and judicial training for judicial kind of officers, magistrates kind of coming into this to really understand the way in which power shows up in these cases, the intersect between race, class, and gender. But this kind of social context training to really help them understand what are the things that make sexual offenses kind of possible and thrive in our country. And you can tell that there is a difference between people who understand rape using this lens that's informed by social context and people who say they are just purely applying, the law. And this is the divide that we actually need to bridge when it comes to judicial officers, because most of the parties in this case agree on the legal kind of submissions. The legal authorities that they are using are not far apart. They are using the same jurisprudence of the Constitutional Court, same comparative law or similar international human rights standards, from CEDAW committee and other international bodies.